Let's get to a huge story that many of you have been following for years. This morning, a Montgomery County judge is hours away from deciding if Catherine Hoggle will go to trial. She is charged with murdering her two young children in 2014.
The bodies of then 3-year-old Sarah and 2-year-old Jacob have never been found. Abby Larico is in the newsroom this morning with what today's big decision will mean. Abby, good morning.
Hey guys, good morning. So after many days when we've expected a decision, today really is a deadline for the judge to make a call. That's because according to state law, the murder charges will be dropped December 1st if Hoggle is not found competent to stand trial before that. Now, we've said this phrase a lot over the few years, competent to stand trial. So to verify what exactly that means, we turned to U.S. and Maryland state code and talked with law professor Amanda Pielstonek, who is not involved in Catherine Hoggle's trial, but specializes in the topic of competency. According to Maryland Code Title III, the question of competency comes up when a defendant in a criminal case, quote, appears to the court to be incompetent to stand trial, or the defendant alleges incompetence to stand trial. U.S. Code defines a competent defendant as able to understand what's going on in court and able to assist in their own defense. Professor Pielstonek says, quote, this is a very, very low standard. Basically, if a person can understand that they are in a courtroom and what the function of a judge is and communicate basic information to their attorney, then they are competent to stand trial. In the Hoggle case, there's been disagreement from both sides over whether this can be influenced by legal arguments or must hinge on medical opinion. We've been in the courtroom as Hoggle's attorney acknowledged she understands what's going on in the case, but denies she's able to assist in her own defense, pointing to medical findings and testimony from a psychiatrist asserting Hoggle suffers from psychosis, delusions, and disordered thought. And as we reported shortly after her children's disappearance, Hoggle has a history of paranoid schizophrenia. But those who want to see her stand trial say Hoggle is manipulating the system, that conversations with her attorney and her ex-husband are proof she's capable of participating in her defense in a trial. Now, it's important to note that competency is different from sanity. Professor Pielstonek explains insanity would be a defense raised during a trial. So that means the defendant would have to be found mentally stable enough to stand trial, but also so mentally ill they would not be considered responsible for their conduct at the time of the alleged crime. Larry, back to you.
All right, important distinctions. Abby, thank you so much.